R.V. Lacasse, 2015, SCC 64. The appellant is Her Majesty the Queen, and the respondent is Tommy Lacasse. In 2015, the defendant, Tommy Lacasse, pleaded guilty in a court of law for his 2011 crime, 2 counts of impaired driving causing death. Tommy Lacasse had been under the influence of alcohol, along with the 2 backseat passengers, when he had lost control of his vehicle. Seen as a result of driving under the influence, as well as speeding, Lacasse had lost control of the car at 4 a.m. on June 17, 2011, in the Bayos district in Quebec, on an open country road. Subsequent to the crime scene investigation, it was found that speed and alcohol were the 2 critical factors resulting in the death of the 2 passengers, as the weather was clear and the vehicle was in suitable condition. The trial judge had administered 2 isolated sentences on behalf of the 2 killed, which were to be served simultaneously. In total, Lacasse received an imprisonment time of 6 years and 6 months, as well as a period of 11 years in which he may not hold a license or operate a vehicle, and that would commence at the time of his sentencing. However, the Quebec Court of Appeal intercepted the judge's order under the Criminal Code RSC 1985 C46, Section 718 to 718.2, which questioned the severity of the punishment administered by the trial judge. The Quebec Court of Appeal then reduced the imprisonment sentence from 6 years and 6 months to 4 years, and the probation period placed on driving from 5 years post-incarceration to 4, which is technically 8 years total. The Court of Appeal believed that such an exceedingly strict punishment would reduce public confidence in the legal system. Supreme Court Justice Richard Wagner then clarified that the reduction set by the Court of Appeal would not stay, and the original sentencing would remain for the crime Mr. Lacasse committed. Just as a note, Section 718 specifically states, the fundamental purpose of sentencing is to contribute, along with crime prevention initiatives, to respect for the law and the maintenance of a just, peaceful, and safe society by imposing just sanctions that have one or more of the following objectives. A. To denounce unlawful conduct. B. To deter the offender and other persons from committing offenses. C. To separate offenders from society where necessary. D. To assist in rehabilitating offenders. E. To provide reparations for harm done to victims or to the community. And F. To promote a sense of responsibility in offenders and acknowledgement of the harm done to victims and to the community. There are 2 issues brought up during this case. Number 1 is, should the trial judge's sentence remain in place or be replaced with the weaker punishment administered by the Quebec Court of Appeal? The second is, was the Quebec Court of Appeal acting ultra vires by becoming involved in Mr. Lacasse's case? The Court of Appeal, having entered due to trial circumstances, believed that the trial judge was too harsh in the administered punishment. The judge, however, operated intra vires, as he had the ability to alter the punishment based on surrounding factors, such as the drunk driving death rates in the area. The judge, therefore, did not agree with the changes made to the imprisonment times and the probationary period placed on Mr. Lacasse's driving. The decision. Due to errors made on behalf of the trial judge, the Court of Appeal was indeed authorized to intervene. Conversely, the Quebec Court of Appeal acted ultra vires by altering the sentencing time administered by the trial judge. Rationale for issue number 1. Made devoid of stare decisis, the judge for Mr. Lacasse's trial did not follow the typical sentencing administered for drunk driving deaths in the past. According to the law, judges are privy to information such as sentencing ranges, which often ensure equality among all Canadian cases. The ranges, however, are not definitive, nor are they to be regarded as averages, as each case may vary based on external circumstances, meaning the final verdict is up to the discretion of the active judge. In this case of the death of 2 passengers due to drunk driving, the judge's sentencing is considered an outlier of the norm. However, this is not justification for appellate intervention. The decision of the trial judge has been made in reference to the surrounding environment. The Bayos region, which Mr. Lacasse's crime took place in, has seen a spike in the number of impaired driving deaths, thereby drawing concern among locals. This largely sociological factor is one that the trial judge felt needed to be addressed, and it is through the administration of a stricter punishment the judge hoped to decrease the injuries and fatalities in the Bayos region in relation to alcohol consumption. Though the defendant was no more morally corrupt than other drunk driving cases, the punishment Tommy Lacasse will serve is believed to be a warning to the surrounding individuals, creating a safer environment. Rationale for issue number 2. Though the punishment administered by the trial judge was made intra vires, it was discovered the trial contained errors which warranted appellate involvement in the drunk driving case of Mr. Lacasse. The Court of Appeal originally became involved under the belief that the punishment was too strict and would cause public dissatisfaction, thereby tainting the image of the Quebec legal system. However, in this situation, both the Court of Appeal and the trial judge made errors in their judgments. Firstly, the trial judge had erred in listing the intoxication of Mr. Lacasse as an aggravating factor in the crime, which would have permitted the Court of Appeal to step in. Conversely, the Quebec Court of Appeal had failed to recognize the local factors that justified the decision made by the trial judge. Ultimately, the errors made by the trial judge had no correlation to the punishment administered, and the appellate intervention was therefore acting ultra vires, resulting in the reestablishment of the trial judge's sentencing with minor changes. Analysis. Operating with the intent of bettering their community, the trial judge's final verdict was ideal for the Bayos region of Quebec. Drawing on visible trends in the community, an increase in the number of impaired driving cases, the trial judge had utilized the power of law as a deterrent meant to lower the casualties of this negative phenomenon. As seen in a dated drunk driving case, it was noted, every year drunk driving leaves a terrible trail of death, injury, heartbreak, and destruction. From the point of view of numbers alone, it has a far greater impact on Canadian society than any other crime. In terms of the deaths and serious injuries resulting in hospitalization, drunk driving is clearly the crime which causes the most significant social loss to the country. R.V. Burnshaw, 1995. In the case of Nathan Burnshaw, he had, fortunately, not been responsible for any casualties while driving. However, he had been pulled over by an officer while visibly drunk and taken into a police station. From both aforementioned cases, it is visible that drunk driving has plagued Canada for over 20 years now, resulting in the death of many individuals, both innocent and not, and judges should, therefore, take any actions possible to limit it. It is through strict punishment that the case of Mr. Lacasse has made national headlines, acting as both a reminder of the severity of this crime and an advisory message against it, justifying its harsh nature. Now time for the survey question. It was discovered that the Court of Appeal did indeed have the power to intervene, as the trial judge made errors, though they did not affect the fair punishment from being administered. Do you believe that the errors by the trial judge, though irrelevant to the issue at hand, should have warranted appellate intervention at all? For yes, click the green check mark, and for no, click the red X. Thank you.